Good afternoon, Judge Masipa.
Afternoon, Chief Justice.
How are you this afternoon?
Uh, Hopefully fine. I'm having a jaw problem. So
Oh.
as I talk and you see me going quiet, maybe it would have hooked or jammed, and then I may not be able to continue talking. But I hope that it doesn't happen.
Or do you feel some pain when you talk?
Yeah, it actually locks, so I can't open it.
Oh,
Yeah.
I'm sorry about that. I'm sorry. Well, if it does happen, we'll definitely understand. Thank you very much for availing yourself for once again
Yes.
for consideration for appointment to the SCA. And thank you for coming to this interview as well. I previously disclosed how you and I know each other, so the commissioners know that you were my researcher law clerk many, many years ago at the Labour Appeal Court. But thank you for coming. The rules that I explained last time about how we go about putting questions to you, interviewing you, are still the same that will apply in this interview. We will be seeking to satisfy ourselves how you meet the selection criteria that we have adopted for the selection of candidates for appointment as judges at different levels. I will ask you some questions, and then I will allow the president of the SCA to ask you questions. Of course, we interviewed you not so long ago, so we are familiar with you. We also have a lot of information that you have supplied to us through the questionnaire and other documents. Therefore, we are not going to try and cover all of that in the questions we'll put to you. Everybody is taken to have read the bundle and to be aware of the information. So we will only focus on those areas where we would like to have answers from you. In terms of your academic qualifications, you hold 3 degrees, BProc, LLB, and LLM from the University of Limpopo and then the University of KwaZulu-Natal, is that right?
Yes, that's correct.
And you got admitted as an attorney in 2004, is that right?
2002.
2002.
Yes.
And after practicing for a certain number of years, you were appointed as a judge of the High Court in KZN. Is that right?
Yes, that's correct, in 2016.
2016, yes. That means you have been a judge for about, what, 8 years, 9 years?
8 years, going to 9 years from next month.
Next month it will be 9.
Yes.
Okay, all right. Now, can you share with the commissioners the breadth of your experience as a judge of the High Court by telling them in what branches of law you have written judgments?
I have, in my previous interview, I dealt with a case that involved the interpretation, the declaration of invalidity of a policy which related to the policy of a private school relating to the payment of fees, which I had to consider whether the application of that policy was in conflict with Section 28 and 29 of the Constitution dealing with the right to education and the best interest of a child. Having considered the relevant issues, found that the policy was indeed in conflict with the.
Okay, I'm sorry, let me interrupt you. I don't need you at this stage to discuss any case. I just want you to reflect on the judgments you have given over the years and be able to say, I've written a judgment in maritime law, I've written a judgment in commercial law, I've written a judgment in patent law, I've written a judgment in trademark law and different branches. So I just want to have an idea of the breadth of your experience.
I understand. So I've written judgments in customary law, in administrative law, in the law of contract, in mostly procedural law, in the law of delict. I have had to deal with some maritime law matters, but then I'm not going to say I've written a judgment in shipping law because they came to me as, on procedural issues as well. I've written judgments in outside the High Court, but in the Labour Court, in employment law. And those obviously involving the Constitution or constitutional law. Yeah, I think that's the sum total of what I can recall.
And then you have acted in the Supreme Court of Appeal. Did that opportunity expose you to other branches of law to which you have not been exposed at high courts?
Well, outside what I've stated, no.
Oh, okay, all right. And you have also been an acting deputy judge president of the KZN division of the High Court, is that right?
Yes, that's correct.
Yes. How did you find that experience to be?
It was quite an interesting experience, having to gain some experience and apply, I guess, some of the previous experience that I gained, managerial work, challenging as well. There were instances where some colleagues were not really cooperative, and some of the things that I asked was mainly senior colleagues, but then even the junior ones would actually behind me be making statements that they refused to do some of the work, you know, and it was shocking for me because it was statements that were coming from judges and not the administrative staff. But I managed them quite well and ensured that the work that needed to be done was done.
Yes. Okay, all right. Can you share with the Commission your understanding of the doctrine of separation of powers?
The doctrine of separation of powers is an important or fundamental principle that in a democratic society, because it ensures that powers are evenly divided within different government spheres. What we have in South Africa is we have parliament, which obviously makes laws, or legislature, and we have the executive, which applies those laws, and the judiciary, which ensures that those laws are applied properly. judiciary has to remain independent in doing their work in reviewing both the functions of the legislature and the executive. To can I sorry ensure that the rights in the Constitution are protected and that laws of the country that have been passed are properly applied by the executive.
When you say the judiciary makes sure that the laws are applied or applied properly, that sounds to me like implemented.
Yes.
Is that what you are saying?
No, the implementation is done by the executive.
Yes.
And then the judiciary basically oversees that both the executive and legislature are applying those laws properly. They would do that by when cases come to court, reviewing those legislations that's been passed and the application that would have been the implementation by the executive.
And would you like to share with the commissioners your understanding of the rule of law?
The rule of law says that, or basically sets out that the law, no one is above the law, and that everyone must conform with the law that has been passed, and that the rights that are there are protected, and also that the judiciary remains independent. So the laws that have been passed must be clear. They must be accessible to the public, and they must be passed in a transparent manner.
President of the SCA.
Thank you, Chief Justice. Good afternoon, Justice Masipa.
Afternoon, President.
Yes, you have previously been interviewed by this body. So my question to you is, what according to you is, let me put it like this, are there any important developments that have taken place since your last interview? You mentioned to the Chief Justice that you were appointed as a DJP, acting DJP. Besides that?
Beyond the scope of the judiciary.
No, within the judiciary.
Yes.
All right, I can
No,
also put it differently and lead you by saying, since then you have
Yes,
had
no.
an opportunity to act again at the Supreme Court of Appeal. Is that
I
correct?
understand.
Yes.
I had indicated at my last interview that I was actually starting my fourth acting stint, which started in October, but then the court obviously sits in November. It was, to me, very informative. Although I had been allocated 2 judgments to write, I could only write one, but then the involvement that I had in that judgment and in other colleagues' judgment, I was quite happy with. I felt I was afforded an opportunity to do the work that I was there to do. Not that I was not afforded that opportunity, but in the previous acting, the judgments that were allocated to me were allocated as a second scribe. In this instance, I had to be, the sole scribe and write a judgment. I indicated that I had been allocated 2 judgments and I only wrote one. And the reason was that the first matter, having received the record and having read the papers, formed a very strong view that there was an issue of conflict arising in that matter. And I communicated with the with the deputy president. And I think at some point I also engaged with you and indicated the issue relating to that conflict. And we agreed that I recuse myself from the matter, and the matter was then replaced with another matter, but however, I was no longer ascribing that matter.
So far, how many judgments have you written at the Supreme Court of Appeal?
Can I ask for clarity? You mean me,
Where you were the scribe?
where I was the sole scribe?
Yes, where you had an opportunity to write a judgment. It doesn't matter whether you were a co-scribe or a sole scribe. As a scribe.
I believe it's 9. Yes.
9. Okay. All right. So you would have realized, which is something that has been lamented quite a lot at our court, that during your last acting stint, we had fewer law researchers to rely on. You recall this?
Yes.
Yes. So you'd agree that candidates who really must be appointed at the Supreme Court of Appeal, all things considered, are colleagues who are able to be self-reliant in terms of doing their own legal research in preparation for the hearing and also in preparation of the judgment.
Yes, I definitely agree.
Yes. So did you have to receive a lot of assistance from other colleagues in relation to, I'm not talking about style issues, I'm talking about issues of substance in relation to your judgment? Have other colleagues had to make a contribution in matters relating to substance in your judgments?
In respect of all the 9 judgments, you're referring to that, right?
Yes, all the judgments that you have authored.
So the first judgment that I wrote when I first came to the court, it's an RAF matter. I would say that I did. It was not necessarily the substance. What the colleague said to me was, you've given too much information, there's nothing wrong with the information that you've given, but it's a little bit too much. And then assisted me with, you could probably remove this and that and that, and still, deliver the message of, a good judgment that you want to do that you'd want to deliver. But then, in time, I believe in terms of substance, no. Yes, there will obviously be comments to judgments, as you know, but the substance of the judgment, no. It's all the work that I would have put in.
Yes. So in terms of measuring whether a colleague is able to fit in properly at the Supreme Court of Appeal, I think you'd agree that one could use the production of judgment as an assessment too. You agree?
Yes, I do agree.
Yes. How soon do you produce your judgments? Have all your judgments been produced promptly?
I'm not sure what promptly would mean. The first judgment that I mentioned, the RAF matter, was handed down during the second term.
Yes, let me put it like this. We have norms and standards. I know that historically at the Supreme Court of Appeal, the expectation has been for a judgment to be issued within the same term. But we do have norms and standards. So my question is whether you have been able to produce judgments within the time stipulated in the norms and standards, Have you had late judgments? If you have had judgments that were delivered late, what were the reasons?
I actually did not work out the date in terms of that RAF matter. So it may, and I indicated at my previous interview that the reason was that there was a delay in the responses that I received from colleagues. What the matter was heard in, I think, around the 15th of August. And the first draft that I had, that I circulated, was on, I think, the 21st of September. But then, because of the delays, I indicated then, and it's still obviously the position, that I received a response from one judge like a week after the 21st of September, but then the other responses took time to come to me. And I think, if you will recall, in last year in December, because of what happened, obviously, at my previous interview, last year in December, I approached you and indicated to you that I was having a similar problem. I had, from what JP Mlambo had said, and Petse, whether I had discussed the previous issue with the presider. I had discussed the issue with the presider, and it seemed to me that she was also having a problem getting to the colleagues, and I indicated to her that I was going to be approaching you to raise the issue with you. You indicated that we should perhaps allow the presider to handle the matter, and let's see how it goes. And it did assist. I was able to have the judgment handed down, I think, in the space of 2 months.
Yes, but any other judgments, have all your judgments, maybe, let me put it differently, have all your judgments been produced promptly in terms of you circulating it? Maybe let's not talk about the ones where you had to wait for other colleagues to,
Yes, they have.
all of them.
Yes.
Within how long? What period of time?
You mean if I'm not counting that one that I mentioned?
From the date of the hearing, yes. When were the judgments circulated to your colleagues, to the panel?
So mostly within a space of 2 months.
All right, maybe I ask this question. Have you had any occasion where you were the cause of a delayed judgment, either in terms of circulating it late or not circulating a revised draft timeously, or a delay in giving input to other colleagues' judgments?
No, definitely not. When I came to the court, I learned from Justice Govan the importance of ensuring that judgments are handed down timelessly and circulated properly. I learned that when colleagues circulate their own judgments, you have to respond as quickly as you possibly can. So whenever it is that I receive a judgment, I stop everything that I do and I attend to those judgments that have been circulated to me and comment. So if I receive a judgment, I think the worst that I would have done was about 3 to 4 days. I indicated, I think it was Justice Petse, that there was some I had returned back to the High Court, and there was some urgent matter that I was dealing with, and I indicated to him when, as well, I would give time to attend to the matter. But then I think about 4 days was the worst, longest period that I would have taken to get back on a colleague's matter. But otherwise, when I receive a judgment, I attend to it on the same day and I return it.
Yes, I'm looking at one of the judgments that you submitted with your questionnaire, the matter of Low versus Patel. I note that the matter was heard on the 23rd of August and the judgment was only handed down on the 9th of March 2023.
Yes.
Do you have any explanation for the delay in the handing down of the judgment?
There was a delay in me receiving responses from colleagues. I did not actually work out the dates on the computer, but then I circulated the judgment whilst I was still at court, which would have meant at sometime in I don't know, I think in November, if memory serves me well. And numerous undertakings were made that I would get comments, and I had not received them, and I kept on following up and following up and following up. I kept on receiving, I received comments immediately from Justice Govan, as I indicated, that he always responds on time. And I considered his comments. I circulated that, and he was the person that came back to me after I circulated and had further comments. But then it took time.
I note that the judgment was a split decision. It was a 3-2. So would you say the fact that there was also a dissenting judgment that had to be authored, did it also contribute to the delay?
Yes, it did contribute to the delay.
Yes. In terms of you have been a judge, a permanent judge for 8 years now. You said it will be 9 years
Yes.
next year. And you'll agree that given the loss of experience and expertise that the court has suffered due to the retirement of many colleagues and the elevation of others, the court requires expertise and experience desperately. You'd agree?
Yes, I agree.
Yes. So what attributes or special attributes would you bring to the Supreme Court of Appeal to complement the remaining expertise at the court?
I believe that I have the necessary experience and expertise to prepare and write necessary judgments. I work well, as I indicated, with colleagues, and I'm able to assist a lot in the judgments. And I am able to work independently. Even without the assistance of researchers, I guess in my previous work experiences, I did a lot of research such that I do not necessarily need to be relying on researchers to be doing my work. So I believe that with the experience that I have, both from being a judge and from being in practice, I have the necessary skills and expertise to deliver the necessary services that are required at the Supreme Court of Appeals.
Thank you. And what are your views regarding collegiality at an appellate court level?
My experience.
No. Your views.
The judges.
Is it important? And if so, why is it important?
Well, yes, it definitely is important. And the reason is that unlike the High Court, obviously, judges have to work together in writing those judgments. There's 5 judges that sit in a matter. You have to, be able or capable to work with each other. And assist each other in dealing with matters to ensure that good judgments are delivered.
Thank you, Justice Masipa. Thank you, Chief Justice.
Thank you, Minister.
I've got no question, Chief Justice.
Thank you. I don't see any indications. Also from the virtual, I'm not aware. Or Commissioner Marmohan.
Thank you very much, CJ. Good afternoon, Judge.
Afternoon, Commissioner.
I see that in your questionnaire, you had an occasion to deal with a medical negligence matter in the Supreme Court of Appeal. And it was a split decision where Justice Basson and Justice Dambuza dissented
Yes.
on the view. So I just want to ask you a question on delict, and I don't want it to be an unfair question. And what I'm asking you, perhaps it might have been something that it could have also been considered in that, but it's something that has been bothering me. I just want to understand. There is a view that factors such as foreseeability and preventability of harm are relevant to the determination of both wrongfulness and negligence. And sometimes you find that there is this overlap between negligence and wrongfulness. To what extent does South African delict law, if there is such a thing, conflate those two concepts? Because a first-year student or second-year student who's doing delict, they know the elements of delict are distinct, causation, wrongfulness, all those things are set out clearly. But in practice, in cases such as medical negligence and all those, we see that some of the factors that needs to be considered in both wrongfulness and negligence seems to be conflating to some extent, and there's some overlap. Firstly, do you believe that there is? If there is, how can the courts deal with the overlap?
I've actually never given it a thought, right?
No, it's fine. You don't have to take it further than that. Thank you very much, CJ.
Thank you, Commissioner. Commissioner Matolo Zepu.
Thank you, Justice Masipa. One of the comments that we received from the Law Society of South Africa is that you still need more time. According to them, that they are not supporting you in the sense that they feel you need more time, and you can do with more acting stints at the SCA. What do you say to that?
Well, no, I think that's a previous comment, not a comment that they made now. I'm looking at that, and my understanding of what they were saying was that there are other judges who have been in the judiciary for much longer than I have, and that was the reason why they were not. Yes, it says from other candidates who are applying for this vacancy, there are several applicants who are more experienced than her and will enhance the jurisprudence of the SCA. That was my understanding of their reason why they were not supporting me.
In your view, have you gained enough experience since then up to now? And how so?
Yes, I believe I have. Well, although I have written one judgment, I've been involved in a whole lot of other matters. both in the Supreme Court of Appeals and outside the Supreme Court of Appeals, which were full court matters that have allowed me to gain the necessary experience that would be of value to the Supreme Court of Appeals.
Chief Justice, may I follow up, please?
Okay, thank you.
Thank you. Good afternoon, Judge Masipa.
Afternoon.
The comment raised by the LSSA is that you are not sufficiently exposed to complex commercial litigation.
Did I say that?
Let's leave aside whether or not that comment was made.
Okay.
Maybe I can get you to respond to the merits of the comment.
Well, I think arising from them, and would have probably been the issue of the fact that I was coming from a labor law background before I became a judge. But as I indicated, I've been sitting as a judge of a high court for more than 8 years now. And I have not been dealing with labor matters. I've been dealing with a lot of commercial law matters, in fact, much more than anything. As you are aware, I'm from Durban, and unlike in Pietermaritzburg, we deal more with commercial work than the Pietermaritzburg court. I'm not saying that they don't. What I'm saying is they also have a lot of administrative law matters, which we don't have. But I have been dealing with commercial law matters, so I'm not too sure where that what that comment would be based on.
You see, Judge Masipa, that comment seems to be borne out by the work done by the GCB. If you go through their comments, they managed to find 7 reported judgments, most of them being your SCA, when you were acting in the SCA, and they managed to find 7 unreported judgments. So from that, there does seem to be a scarcity of comprehensive judgments written by yourself in litigation of substance.
Yes. No, I understand where that's coming from now. What has been reported by the GCB is in respect of mainly the reported judgments. I have written a lot more judgments which are available on SAFLI. In fact, some comments have been made that I like writing judgments versus delivering extempore judgments. But I have a lot of commercial law matters that I dealt with, and judgments are available. They may not be reported in the law reports, but on SAFLI you will find them.
And lastly, I think that the concern gets exacerbated when the questionnaire asks for your 10 most significant judgments, and you only provide 9.
Well, I think my understanding would probably have been that they wanted them for the past certain period and not, I believe that what was required was the reported judgments, not those ones that were published in SAFLI. But I have a lot of judgments that have been reported on SAFLI.
Thank you, Chief Justice.
May I also ask you about the cases you have listed under question 16 in the questionnaire? Have you got your questionnaire there? Question 16 is at page 9, paginated page 9.
I'm not too sure that.
Have you got your bundle? Have you got your bundle in front of you?
I have the bundle.
which has got your questionnaire.
Yes, you said, where?
Page 9.
Justice, page 9.
Yeah, question 16. Can you see there? Are you there?
Yes.
Yes,
Item number 16.
yes.
Okay, sorry, it's my page 10, that's why I'm asking.
Well, on what I have, it starts on page 9 and continues to page 10.
Okay.
See, question 16 is, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. You see that?
Yes, I do.
Would you agree that what the question requires is that you must not just give the case, but you must also say why you say it's one of the most significant of your judgments?
Yes.
Okay. You see, if you look at your answer under question 16.1, you give the Zondi judgment there, and then you say unanimous judgment after convincing 3 senior members of the bench who initially were.
Sorry, pardon, I beg your pardon, Chief Justice. Which one are
I'm
you?
sorry. No, I'm sorry. Sorry. No, I'm looking at the wrong page. I'm sorry. I'm sorry. I'm terribly sorry. Commissioners, if there's somebody who has a question, if they can ask in the meantime while I am sorting myself out here. Let me see, Commissioner,
Chief Justice, the page is page 10
is it?
of this particular applicant's application, where the item 16 appears. So it's page 10 up to page 14.
I'm sorry. Thank you, Commissioner Mugaitobi. I think that please go ahead. Go ahead. I got mixed up with my.
Good afternoon, Judge Masipa.
Afternoon, Commissioner.
In the context of a commercial contractual dispute, how do you see the principles of good faith and fairness fitting in?
Contracts are concluded on the basis of good faith, and it is expected that both the contracting parties are entering into the contract in good faith, and with all the bona fides, and where it ultimately appears that there is no good faith in a contract, then the contract, the wrong party will obviously not succeed, with the case.
Sorry, I'm not clear on your answer.
When parties are contracting, they are contracting in good faith. So you have to really believe that the other contracting party is being or having all the necessary bona fides in concluding the contract with you. So what I was saying is where there is no good faith in a contract, and there is malafides, the aggrieved party, if there is a case in court, would have an election basically on whether to still have that contract enforced or to be seeking an order to be released from that contract.
So as the judge, could you use the principle of good faith to interfere with a contractual agreement?
Yes, I would, because of the importance of good faith. It's what informs, the intentions of the parties in concluding a contract.
Are you aware of the SCA and Constitutional Court cases that have, in the last couple of years, looked specifically at this question?
No, I have not had to deal with the issue, so I'm not aware of those.
Because in fact, the courts have held that good faith is not a freestanding principle, that in itself can be used to find against a party in a commercial contract.
Could I just follow up? What about fairness? If a party comes along before you and says, I don't like this clause in a contract, I believe it is unfair, I want you as a judge to strike it from the contract, can you do that?
Again, I've not had to consider that issue. When parties contract, it is taken that they have read and they've understood, they understand the base upon which they're entering into a contract. So the difficulty of my answer is that in view of the case that's been mentioned, I am not aware of. I'm at a disadvantage of saying whether that should be done or not.
Thank you, Judge.
Thank you. I don't see any other indications. And also from the virtual, I've not been told there is any hand. We have come to the end of this interview. Thank you very much once again, Judge Masipa, for availing yourself. You are now excused.